Well, welcome to the second part of our four-part series on business succession planning for the water well industry. I'm Jesse Richardson, and today we're going to talk about business arrangements for succession planning. And I'm going to have to move through some of this pretty quickly, and last time we did this, we got some questions after we had wrapped up. So if you have questions, go ahead and enter those questions at any time. And if we don't get to the questions right away, we'll get to them at the end. And if I don't get to your question, we'll try to get back to you. So if we go to the next slide, what we're going to talk about today, types of property ownership, different types of business entities, business agreements, and conclusions. I want to get a little participation from everybody today, and that starts now. So we have a poll question for everybody. And the first poll question is, do you own a business? And we'll ask you just to click yes if you do own a business and no if you don't own a business. And I'll give you a couple minutes to do that, or not a couple minutes, 30 seconds or so to do that. We'll see what the results are. Looks like about a quarter of you own a business, about 75 don't. Maybe just a couple more seconds. If you haven't already, go ahead and fill out the poll. All right, we will close the poll. And we had about 1/4 of you who own a business and 3/4 who do not. But those of you who do not probably are involved in a business in one way or the other, or you probably wouldn't be interested in this. So if we go to the next slide, I'm going to really quickly talk about the types of ways that you can own real estate, or in many instances, any other type of property, even bank accounts and the like. And I'm going to do this pretty quickly, but sole ownership is the simplest, and that's where you just have one person owning the property. And it can only be one person. Once you get more than one person, you have to have some way to jointly own the property. The most common and the default type of ownership is called tenancy in common. And in a tenancy in common, each of the parties holds an undivided interest in the property. For example, if we have 3 people, each of those people own their interest in the whole property, and it might be 1/3, 1/3, 1/3. It could be 1/4, 1/4, 1/2. But they own their piece of the property. And when that tenant in common passes away, their interest in the property would go through their will or to their heirs. Also, one tenant and tenants in common can, for example, lose their interest in the property if they're in an automobile accident and they get sued, or if they have some liability that gets attached to the land. So that can cause some difficulties, particularly with business property. And we try to avoid tenancy in common property. The next type of property is joint tenants with right of survivorship. And in that type of property, each has to have an equal share. So it's either 1/2, 1/2, or 1/3, 1/3, 1/3, or 1/4, 1/4, 1/4, 1/4. And when one of the tenants dies, their share goes to the surviving tenants of the property. But just like the tenants in common, if a joint tenant with right of survivorship gambles away their interest of the property, or some debt attaches to it, that their portion of the property can be separated from the rest and essentially be tenants in common. But a lot of family members will own their property as joint tenants with right of survivorship, so that when one of them dies, the will does not apply. If there is a will, the property automatically goes to the other tenants. Finally, we have tenants by the entireties, and that's very similar to the joint tenant with right of survivorship, except in a tenants by the entirety, it can only be married couples. And the law looks in this instance at the married couple as one individual. So this can be really good with respect to debts, where if one of the spouses has a debt, that does not attach to the land, because we're looking at husband and wife as one person. So in order for the liability to attach to the land, it has to be husband and wife's liability. And so in a lot of states, married couples can own their property in this way. And it's particularly good, for example, for the family home. Finally, and what we want to focus on in this webinar is types of ways to own the property in a business. And we're going to focus on sole proprietorships, partnerships, corporations, and limited liability companies. Next slide. So the types of business organizations that we have are outlined here. Sole proprietorship. We have two types of partnerships. You can have a general partnership or a limited partnership. Two types of corporations, and we'll talk about that, but you can have a C corporation or an S corporation. And finally, a type of business entity that is really popular these days, particularly with small businesses or businesses that own real estate, is the limited liability company. Let's start with the sole proprietorship. That is one person. It's easy to create. The owner is in complete control, very flexible, and basically the owner just makes the decision. So that's some of the advantages. The disadvantage is that if the business is a sole proprietorship, and about 98% of businesses in the U.S. are sole proprietorships. So those of you listening, many of you are probably a sole proprietorship. The problem is that if there is any business liability, whether that be an accident or debts of the business, they are going to attach to the owner's personal property and real property. So example, if I own a business as a sole proprietorship and I run into problems, I could lose my house or my car or my other property. The other issue, which is really key for what we're talking about here today, is it's really impossible to pass that down to the next generation. There's really no mechanism to do that since it's a sole proprietorship. And it's difficult to raise money because you're just one individual. Next slide. Now we're going to talk about general partnerships. And a lot, you can be in a general partnership, I want to say this, whether you have a written agreement or not. So if 2 or 3 or 4 people get together and start doing a business, just on a handshake. But these days we can't shake hands, so maybe it's a fist bump. But they just say, let's start printing T-shirts. And they go out and buy a machine and they start printing T-shirts and they share the expenses and the profits. That's a partnership. I don't recommend that you do that. I recommend that you always have a written agreement. But partnerships are easy to create and maintain. We just talked about that. You can create a partnership without even knowing about it. It can be very flexible, very informal, which can be an advantage, but it can also be a disadvantage. And the partners share the profits and losses equally. There is at least one huge disadvantage with a partnership, however, and that is that each partner is individually liable for all liabilities of the partnership, whether that be a debt or whether that be some type of accident. In a well contracting business, if you're in a partnership and one of the partners is putting in a well and there's an accident and somebody gets hurt, the other partner is liable for that. And so that's a huge problem, and I would avoid partnerships for that reason. Partnerships are also dissolved upon death of any of the partners, so it's difficult to pass it down to the next generation and difficult to raise financing. Next slide, we're going to talk about limited partnerships. And limited partnerships are very similar to general partnerships with a couple of little twists. You pretty much create the partnership the same way, except this must be in writing. The difference in a limited partnership is that one person has to be a general partner, and they are personally liable for all of the debts of the partnership. The other partners can be limited partners. Next slide. So the limited partnership is an agreement between two or more people. One of them has to be a general partner. One or more of them can be a limited partner. And often we will call a limited partner a silent partner. They have limited liability. And if we look at the next slide, the general partner assumes all management responsibility and all personal liability. The limited partner, or you could call them the silent partner, puts in cash or assets, but they have no say in what happens in the business. And their liability is limited to the amount of the investment. Just like any of the types of business entities that I'm going to talk about that have limited liability, you have to be very careful with that limited liability, because the limited partner in this case can forfeit that limited liability by taking part in management of the company or by basically acting like it's not a limited partnership, but they're running the business just as they would run any other business. Next slide. So there are two types of corporations. First, I'm going to talk about the C corporation. And that is the most common type of corporation. The corporation that, most companies on the New York Stock Exchange are C corporations. Small businesses are less likely to be a C corporation. But the big advantage to a C corporation is limited liability. If I own a part of a C corporation, I'm a shareholder. So a lot of you probably own stock in a company. You are a stockholder, you are an owner of the company. But I'm trying to think, I had a company that I didn't own stock in Enron. I know what it was. I owned stock in Freddie Mac. And Freddie Mac went under pretty much. My stock value went down to about zero. The point is that I lost most or all of my investment in that stock, but nobody could come after me for Freddie Mac's other debts. I have no liability for that. And I say ha ha on my table here because with small businesses, a lot of small businesses don't follow the formalities. If you set up a corporation, that corporation is a separate entity, and you have to treat it like one with a separate bank account. And you don't mix up the money, and you have meetings, and you keep a minute book, and you treat it like a business, like a separate entity. If you don't do that, a lot of times the courts will come in and say, wow, you didn't treat this like a business, you're individually liable. You mixed your personal and your business. Now, a C corporation, like the other types of organizations that I'm going to talk about, very flexible. You can have shareholder agreements and do just about anything you want, and we're going to talk about that. The other great thing is that you can pass the shares down. You can allocate the management responsibility under these shareholder agreements. Very easy to pass down to the next generation. Now, the difficulties or the disadvantages. Follow those corporate formalities. If you don't, you have problems. The other big problem is that C corporations are subject to a double tax. And so I advise people do not own land in a C corporation. Why do I say that? Land usually appreciates. If I buy land for $100,000 and it is now worth $500,000, it has appreciated $400,000, and it is impossible to get that land out of the corporation without paying two taxes on the $400,000. So be really careful. There is one way to do it, and it takes 10 years and a lot of patience. If you own land in a C corporation, talk to your accountant and your attorney right away. And then the other thing, and we're going to talk about this too, you have to have a business agreement that matches your business, your family. Don't let the lawyer give you a boilerplate agreement. Next slide. And this just talks about the limited liability of the shareholders again. And again, shareholders are not normally personally liable for corporate obligations. You can lose the entire value of your stock investment, but that's all you are going to lose unless you don't follow the corporate formalities and the courts pierce the corporate veil, we call it, and go after you individually. So those are the things that you have to be careful about. The next slide talks about the double tax, and this is really too complicated for us to talk about in this short webinar today. But those of you who are accountants or who are familiar with real estate and with accounting principles, when you die, the basis of your property steps up to the fair market value at your death. So, for example, the basis of your property is basically what you purchased it for, less depreciation. So if I bought land for $100,000, when I die, it's worth $1 million. If I sell it, if my heirs sell it the day after I die, the basis has been stepped up to $1 million. They pay no capital gains tax. If I were to sell that property during my life, I would pay a capital gains tax on the difference between what I purchased the property for and what I sold it for. If you own the land in a C corporation, the corporation never dies. So you never get that benefit of a stepped up corporation. The next bullet talks about that conversion to an S corporation is one of your only solutions. Now, the next two bullets kind of soften the blow a little bit. There are low capital gains taxes at the present time, and the latest tax changes keep that pretty low and have some other provisions that kind of soften the blow here. So maybe it's not such a horrible thing. At least it's not as horrible as it used to be when the double tax meant that you might pay 50%, 60% in taxes out of that. So on the next slide, I start talking about the S corporation. And the S corporation is a lot like a C corporation. This is the IRS created S corporations because the IRS is your friend, and they saw the disadvantages of a C corporation. So they said, we want to give small companies something that will allow them to have limited liability but avoid paying the double tax. So again, you have that limited liability, which is easy to lose, but there's no double taxation. It is a corporation that never dies, so you can keep it going for a long time, easy to pass it on to the next generation. The disadvantages are, again, you have to follow those corporate formalities or they're going to pierce the veil and go after you individually. And again, in this short webinar, I can't get into a lot of depth, but there are certain circumstances in an S corporation where you might pay a double tax on land or other appreciating assets. Basically, the IRS made a mistake when they were crafting these statutes and laws. And in a certain circumstance, you can pay a double tax. So if you own land in an S corporation, just be really careful. If you don't own land in a C or an S corporation, they're perfectly fine in most cases. The last disadvantage there is also a disadvantage with respect to any of these corporate entities. And that is that if you allow the attorney to do a boilerplate agreement that's not tailored to your particular business, that can really cause problems in the long run. The next slide just briefly summarizes some of the IRS requirements for the S corporation. If we can go to the next slide, the corporation, again, it avoids the double tax, but the IRS says that the corporation has to be a domestic corporation. You have to have fewer than 100 shareholders. You can only have one class of stock, and no shareholder can be a non-resident alien. So next, I'm going to talk about what is probably the hot business entity of the day. It hasn't been too long ago where the IRS recognized limited liability companies, or LLCs. And this is truly an entity that you have limited liability with all of the caveats to that you have to follow the corporate formalities. You can't intermingle personal with business assets and that type of thing. But it is treated as what we call a pass-through entity. You can basically be taxed like a partnership, so only one level of taxation. So that's a huge advantage, that you only pay one tax, but you get the benefit of limited liability. The disadvantages are that states have different laws on limited liability companies. Not all states recognize them, and it can give the owners a false sense of security, because you're like, well, I'm in a limited liability company, I'm bulletproof now. And that's not entirely the case. The next slide goes into this a little more in depth. It is a hybrid creature with limited liability but tax advantages of a partnership. They are very popular now. And the next slide elaborates further. They're creatures of the state, so you need to look at the state law and to see what the rules are. You file articles of organization with the state to form it, and it is a really good business entity for holding land as an investment. So I know a lot of well contractors, I mean, you might own the land in the building that you operate out of, you might not. But for anything that you own land, limited liability companies provide a really good vehicle. I talked about that false sense of security, and that gets to my next slide, where I talk about the magic LLC, and I see this a lot. It is great, limited liability and no double tax, but we've talked about already, limited liability is not really limited liability. I'm going to talk about in our last session, the best way to protect yourself against liability is liability insurance. That's less expensive and more effective. People seem to think that limited liability companies will make all your problems go away, the lion and the lamb will lie down together, and your business that was not profitable will suddenly become profitable. And that's really not the case. I have gotten a lot of phone calls where people say, well, my neighbor, they got an LLC. I heard that they're really great. I want to do an LLC. And I'll ask them, why do you want an LLC? Well, I want unlimited liability. I want to do this. And the lawyer's favorite answer to any question is, it depends. And so don't get hung up over this great LLC, which can be very great. And the next slide really gets to the point. Today, given the fact that business entities are very similar, don't worry so much about the liability. Worry about getting business agreements that will do everything that you need to do for your family. But there is one situation where liability is a big issue, and that's the partnership. I would not want to be in a partnership. And what I say here is what I call the accidental partnership. And I don't know how much this happens in the water well industry. But if you share equipment, if you market things together, if you work together with another person or business, and you don't have some written agreement, the courts are going to say you're a partnership because that's the worst thing you can be. And if one partner has a lot of assets and the other one doesn't, they're going to go after the partner that has a lot of assets. So you shouldn't do it. One example I'll give real quick are leases. If you do a business lease, a lot of times there's going to be provision in there. This is not a partnership because leases look like partnerships in some ways, and you don't want to be a partnership. Too much liability. So my conclusion on business entities that I talk about on the next slide is that limited liability is an illusion for the most part, except with partnerships, where it's not an illusion. It can be very painful. So get adequate liability insurance, and we're going to talk about that more at our fourth webinar, the last in this series, in a few weeks. What should you worry about? You should worry about business agreements. And I talk about that starting on the next slide. Business agreements, and this can be whether it's a corporation, partnership, LLC, whatever it is, you have a lot of flexibility. You can do a lot of things. You should talk about control. Who's going to manage the business? Who are going to be the officers and directors? Lay out the responsibilities for all these people. And I recommend more than one manager, because if something happens to one of the managers, who would take over? The next slide talks more about control. How many signatures for checks? Do you want to require 2 signatures if it's a large amount or something of that nature? And again, what happens if a manager dies or becomes incapacitated? Your will and your power of attorney don't work here. You can't put in your will or power of attorney that somebody takes over for you. That has to be in the business agreement. Do you want to require a majority vote or a supermajority for the members to take action? You can really do a lot of things in the business agreement. Another area where you can make mistakes that can be a problem is setting out the purpose of the company, of the business. And I've seen this happen a lot of times, and you do that when you organize and you do that in your business agreement. Sure, the generic purpose is to make a profit, but what if your agreement limits what you can do? The purpose of this business is to install water well systems for our clients. What if later you want to do septic systems or alternative septic systems? Is your purpose broad enough to do that? So you don't want to be too specific. You don't want to be too narrow. You want to put in your agreement whether a majority vote is okay to change the purpose, or do you want a supermajority? How about selling assets? Do you want a majority of the people voting to sell assets, or do you want a supermajority? So the next two bullets talk about that. How do you want to control the business? Now, the next slide gets into a very important issue, and that is buyout provisions. And buyout provisions talk about if there's a divorce, if there's a death, and it's usually going to be a spouse that is not part of the family that started the business. And if you don't have a business agreement, that spouse can usually say, I want my $1 million today, show me the money. But in a buyout provision in a business agreement, you can set the terms of the buyout. You can, as long as it's reasonable and it's evenly applied, you can say book value or whatever. You can talk about we're going to have an installment purchase over 10 years, 20 years at a reasonable interest rate. And then a very important issue that we're going to talk more about in part 3 of this series, in part 4 of the series as well, as you might be able to use life insurance to buy out that deceased owner's interest from the surviving spouse or the children. So there are a lot of different ways you can do that. So here's our next poll question. For those of you who own a business or involved in a business, does that business have a buy-sell agreement? So I'll give you a few, 30 seconds or so to say yes or no, or maybe you're not sure if you have a buy-sell agreement or not. A few more seconds if you would like to add your vote. So I'm going to end the poll now, and we have about 50% that have a buy-sell agreement and 50% that aren't sure. Buy-sell agreements are very valuable. The next slide talks about another important issue that business agreement can talk about, and what happens if one of the owners dies or if something happens to terminate the business. Can you do something to make sure that the business continues? And then secondly, if the business does indeed terminate, who gets the assets? And all of that can be laid out in the buy-sell agreement or in the business agreement. Now, the next topic, probably one of the most important. I know that I got a lot of questions about this at our last one, protection from divorce. And this is, I think, a really great thing that you can do with a business agreement. You can do almost anything with a business agreement. And what you do with this is you say, I don't want anybody to be able to own this business except the lineal descendant of grandpa or grandma, whoever started the business. And you can put that into the agreement. So you can say, no in-laws can own this, only my son, my daughter, my grandchildren, they are the only ones that can own this. You got to think about your adopted children, what's going to happen with them. Do you want them to be able to inherit this? And you also have to think about there may be there may be a situation where you want an in-law to be involved in the business or an outside party. But again, you can craft that business agreement to say no one but lineal descendants of grandma or grandpa, unless a 2/3 vote of the members allows them in. So this last bullet, I'm sure a lot of you are aware of. You have to think about divorce when you're doing your business agreements. It's not a pleasant thing, but it's a thing that unfortunately happens quite a bit. And my next slide talks about, when I talked about installment sales and setting the value of the business interest, that's really important in these divorce situations, or even in the death situations where you don't want son-in-law or daughter-in-law to be able to inherit the property. But divorces are very important because without the business agreement, you might have your ex-husband or your ex-wife working side by side with you every day as a part owner of the business, and that could be really painful. The last thing I want to say about protection from divorces is prenuptial agreements. They are probably the best way to protect the business from divorce. A lot of people are doing prenuptial agreements now. A lot of people have second marriages. A lot of people I have had a lot of clients tell their children, no prenuptial agreement, no part of the business for you. You have to enter into a prenuptial or I'm not going to leave the business to you. Divorce is the thing that can destroy a business very quickly. The three things that you need to have a valid prenup are full disclosure of everything, the values, the assets, the liabilities of both the husband and the wife. Both husband and wife have to be represented by an attorney, and you can't have any unconscionable provisions is the final bullet. And by unconscionable, I mean that it's so unfair that the court just would not be able to enforce it. So divorce is one of those things, one of the 5 Ds that we talked about earlier, and that we really need to address in the business agreement. The next thing is something that a lot of people don't think about, and that's disability. What happens if somebody becomes disabled? Disability insurance is one possibility. I'll talk about that more on part 4. It can be really expensive though. But the thing that all of you should do is to have a contingency plan that if something happens to one of the shareholders, if something happens to one of the people in the business, then you should have a contingency plan for that. And that's the last bullet on that slide. So now I'm going to go through some samples and then we'll wrap up and have time for questions. So the next slide shows a sample agreement provision for ownership. And in this, I say that only direct lineal descendants of Jesse J. Richardson Jr. of Morgantown, West Virginia, may own an interest in this business. Any transfer to anyone other than a direct lineal descendant of Jesse J. Richardson Jr. shall be void and of no effect. That means that you can't transfer it to somebody. This can be really helpful if you have an heir or somebody involved in the business who tends to run up debts or liabilities. So, maybe they go to Vegas for the National Groundwater Show. They gamble away all of their money, and the casino wants to take over ownership of their shares in the business. Can't do it because they're not a lineal descendant. Now, they can put a lien on it, they can do a lot of things, but they cannot take over that business or that interest in the business. Now, the next slide shows, and I've had some people say, well, wait a minute, my son-in-law or my daughter-in-law, man, I wouldn't be able to continue this business if it wasn't for them. So I need to have them in the business. Well, you can put in the agreement, no transfer to anyone but a lineal descendant of Jesse J. Richardson Jr. shall be valid unless there is a 2/3 majority of the owners of the business vote to admit the new owner of the business. So this allows you some flexibility if you want to have outsiders from the family, in-laws, outlaws, or even somebody that's not in the family participating in the business. You might want to in some circumstances. This allows you to do that. Another way to address this issue of who owns the business, who you can transfer an interest to, is a right of first refusal. And in that, I have a little example here. And again, I'm getting these to fit on one slide. So there would be more language, but no share or ownership interest in this company may be sold without the seller first offering the sale on the same terms and conditions to the company. So you have to offer it back to the business. Then you have to offer it to each shareholder. And so written notice shall be given to the company and the shareholder, and then the company will have 10 business days to respond. The shareholders will then have 5 days to respond. So that means that if that person wants to sell the business to somebody else, that the other owners get the right of first refusal. So that's a good way to cut off those transfers that you don't want to happen. I talked about setting the purchase price of the shares of the business, and that I talked about on the next slide. What can happen is that even if you have all of these agreements and all of these provisions that I'm talking about, if somebody dies or gets a divorce, or the shares do get transferred and that shareholder is ineligible to be an owner of the property of the business, they still are entitled to some sum of money for that interest. And they're going to want $1 million or $1 billion or whatever, and they're going to want it today. So in the business agreement, this is another way to protect against divorce, but it also is a good protection in the case of death or just any type of disruption in the business. I don't know how many of your businesses could pay $1 million to somebody or pay half of the value of the business. Here we say, okay, it's going to be the book value of the company divided by the number of shares. Now, there are problems with using book value, but that's definitely going to keep the value down. You could have an appraisal done. any reasonable type of valuation would work here. The point is that you don't want to be involved in litigation where you have to pay lawyers to fight out how much is this worth. And so you want to set something up in the agreement that establishes how we're going to value it so you don't have to argue about it later. Then the next slide talks about once we've determined the price of it, how is it going to be paid out? And in that case, we usually say something like semi-annual payments amortized over 15 or 20 years, interest rate set at prime based on the date the obligation was incurred. Interest rates are pretty low now. And these can be pretty favorable terms for the business. And so these are all things that you should think about. And so in starting to wrap things up today, the next slide talks about the fact that this is a team approach. As bad as this sounds, you should really talk to a lawyer. You should have an accountant on board. You might have to deal with a lender if you need to borrow money. A financial advisor is a good person to have on board. We're going to talk more in part 4 about the fact that you might not like insurance agents either, but they are people who can be very, very useful in these types of situations and that you need to talk to in these situations. An extension agent, depending on the situation, and maybe others. Think about what type of expertise that you are going to need. Something that I'm going to talk about in part 4, I should have added to this list perhaps, is a facilitator. Sometimes family members don't get along with each other very well. And sometimes it's good to bring in a third person to help facilitate family discussions. So in conclusion for this, and I know I went over a lot of stuff today in a really short amount of time, but on the next slide, I try to pull it all together. And I think this first bullet is the most important to me. I see so many family businesses that go to a lawyer, and this is the lawyer's fault. There are good lawyers and bad lawyers, but most lawyers, if you go to the lawyer and say, I heard about this LLC, it's so great, form an LLC for me. The lawyer is going to say, sure, great, that'll be $1,000. Here's your operating agreement. Here are your documents. Give me that check. I'll see you later. You really need to say, time out, stop. I don't want a boilerplate agreement. This is a family business. This is something that's been in the family for a while, very important to the family. This is a water well business. It's different than a lot of the businesses that you deal with. I want you to structure these operating agreements to me, to my business. I don't want people outside of the family owning this. I want to protect the business from divorce. I want to protect the business from disability, from death, from those 5 Ds that we talked about on the first session. If you don't stop the lawyer and talk through this, you're probably not going to get it. You're probably going to get a boilerplate agreement that can cause a lot of issues. The other thing, and I hate to sound like the Grim Reaper, but keep those 5Ds in mind and plan for the worst case scenario. The next bullet talks about that worst case scenario. We plan for the worst, we hope for the best. Another thing that I want to impress upon you from this part 2 of our series, I've talked about it a couple times. Keep your personal and your business separate. Don't mix up the money. Don't keep it all in one pot. Treat the business as a separate entity. Keep your personal stuff apart from that. If you don't, it can be a problem in court. It can be a problem for liability. Something that we're going to talk more about in part 4, communication. All of this that I talked about today, you're going to have to talk to your family members and see what they want and how you should move forward. And last and certainly not least is the plan. Think about what you want in the future and how you want to get there. So that's what I wanted to talk about today. The next slide, I ask if you have any questions. I have not seen any questions yet. I'll be on here for a couple more minutes. While I'm waiting for questions, I will remind you that if you are not a Water Systems Council member, please go to our website where you can get a membership application, or if you would like to call Aaron Kaufman, who is our Member Services Director. Her phone number is there. Aaron would be happy to help you with any of your questions or concerns about membership. Aaron would be happy to tell you about the many benefits of membership in Water Systems Council. While, if you have any questions, please send those in the chat box. On the next slide, I talk about the part 3 and part 4 of this series on August 6th at 4 p.m. Eastern Time. I'm going to finally talk about what a lot of you have been asking for is estate planning. What can we do in estate planning? And then on August 27th, I'm going to talk about insurance, and then I'm going to try to tie everything together. I did get 2 questions from the prior webinar that I can answer now. One question that I didn't get and I wasn't able to address was, can I use a living trust to transfer part of my property to somebody in my will? And the answer to that is yes, and that happens a lot. We'll talk more about this on August 6th, but you can set up your living trust and you can put in the trust how you want your assets to be distributed. Then in your will, you say, when I die, I leave everything, or I leave these certain assets to my trust. And then the trust will take that and have control over it. So trust can be a very good way to arrange things, and we're going to talk about that more on August 6th. The second question was also about trust and said, if I want to protect my assets and my children's assets from divorce, what if I set up a separate trust for each child? And the answer is yes, you can do that. However, you should be aware of some income tax issues that might come up, and might be easier to do things like a business agreement and a prenuptial agreement. However, setting up a trust for all your children is a possibility. You can do that in one trust, or you can set up a separate trust for each child. If you have any other questions after we close our webinar here in a minute, feel free to contact me, to contact Aaron, to contact the Executive Director, Margaret Martins, and we would be more than happy to try to address your questions. So again, thank you for coming today, for watching the webinar, and I hope to see you all virtually on August 6th at 4 p.m. Thank you so much.